Good morning. I thought I'd give you a quick video this morning in light of the potential Trump indictment. So I kind of wanted to give you like the procedural status and kind of where we are and what it means. Not legal advice. Like, subscribe, and please share. And I'm not a criminal lawyer, but so take it for what it's worth. But this hopefully will kind of frame things a little bit about it. So Trump apparently was indicted by a grand jury in New York, and a grand jury is a group of people in New York. I think it's up to 23 people in a grand jury, and they get together. And I think the minimum amount of time is generally like 3 weeks, but it can be extended to months, which I think the Trump grand jury was. They get together. The prosecution, if they are trying to get a indictment, they present evidence of whatever crime they're intending, and then they argue the law to the grand jury. There's no defense presentation. And then the grand jury, after they hear all the evidence, they take a vote. And if there's, in New York, and I'm referring to New York, if there's more than 12 out of that 23, there could be less than 23, but I think there was 23 in this case, but it has to be 12. If 12 vote that it's with, and I'm going to give you like a general standard of proof, because standards of proof in law are often kind of vague, but it's basically with, if there's reasonable certainty that a crime has been committed and that the defendant was involved in the crime, then that's enough for the grand jury to, in essence, issue an indictment. And so that's apparently what happened in this particular case, but we will know more on Tuesday when the indictment is unsealed. Grand juries are used especially when it's like a political matter or a sensitive matter, because it's the idea is that the citizens are voting for it as opposed to an elected official like a DA or an attorney general. So it's supposed to look fairer, but again, the standards are pretty low. So in California, as an alternative, and I think it'd probably be the same in New York, as opposed to a grand jury, like the attorney general or the DA could indict you for any crime, and then you'd have a preliminary hearing. So in essence, they, as opposed to a grand jury, they would have a hearing in front of the judge, and they would put on a minimal case to establish, again, basically, with reasonable certainty that a crime was committed and that you, unfortunately, were the guy. And if that is the case, then they hold you over, and the charges would stay. And I think it's called the information in California, ultimately, and then an indictment. And then there'll be an arraignment, and there'll be arraignment in if as we know there actually is a grand jury indictment in Mr. Trump's case, or President Trump, former President Trump's case, then there would be a preliminary, there would be an arraignment. An arraignment is basically where all the charges are read. So in this count, if there's like 30, apparently there's like 30 or 34 charges related to the falsification of business records, but that could change because I guess it's an open indictment and charges can be added. So they'll theoretically they'll read all the charges, and that could be very long. It may not be an advantage of the defendant for that, because maybe they don't want that to be out in the public. So we'll see if they want it to be read. But ultimately, then there'll be some plea. I would guess not guilty plea, and then there'll be dates set, and the case will go forward from that. Um, However, and by the way, I think as to these particular charges, if they relate to the Michael Cohen matter, it would be tough not to be able to get an indictment since Cohen got convicted and he did it on behalf of somebody else. But that doesn't mean you're going to get a conviction. So an indictment is at a much lower bar than a conviction. So the basic difference is in a criminal proceeding, the standard of proof is different. It's got to be beyond a reasonable doubt, and it has to be unanimous. If it's 12 jurors, it's got to be all 12. And then you could have a trial, and you may not get a unanimous verdict, and that's where you get a hung jury. And also, you could theoretically have a court, a judge try these cases, but generally a defendant wants a jury because they tend to be offer more potential for especially guilty defendants. But as a general rule, defendants want a jury. But if it's a hung jury, then you could have a retrial. But in this case, we could be in an election, the people could be dead. So part of, I think, strategy here is a delay tactic because it makes sense. So I would expect, though, but even before proceedings begin, I don't know what, but I expect the Trump camp to file or attempt to block the legal proceedings themselves. I would guess, because this has been their tactics in the past, they'll file something with the Supreme Court. I doubt the Supreme Court will give them any relief. However, it'll buy them time. And, as we get farther down the road, we get closer to the election, and then there may be an argument that proceedings shouldn't go on during an election. So I think in part that might be play. Then, depending on how that all goes, then you'll have proceedings, you'll have court proceedings, and although you have a right to speedy trial, so in this case, Trump has a right to speedy trial. It's a constitutional right, but it can be waived because it wouldn't be in his best interest in this matter to get a speedy trial. He'd want delay. He'd also want time to develop his defense. Many issues will arise during the trial. They'll all need to be litigated. There'll be issues about evidence, about witnesses. So there'll be motions filed, and I'll do a video about motions, etc. But there'll be motions filed in hearings. Then there'll be challenges to the jury instructions. The jury instructions are basically the law of this particular case. Then they're read by the judge to the jury, and then the jury makes their decision based upon those specific instructions and how the facts apply. There also probably will be, or I presume there'll be an attempt to attach other charges to these. There'll be, and I would assume those attempts will be to add felony charges on top of what may be misdemeanor charges. For example, they might claim there was an attempted tax evasion or attempted finance campaign law violation, which might be a felony even if it's not completed. An attempt, in other words, if you attempt to kill somebody, that's still a crime even if you're not successful. So they may try to attach something like that to the misdemeanors, but I don't know. I'm not a criminal lawyer, so this is kind of like just a general overview. If we have a trial and if someone gets convicted, and even if they got convicted on 30 counts, and even if all those counts had jail time, and generally in a misdemeanor, if you're convicted of a misdemeanor, at least in California, I think it's less than 1 year in jail and a fine. But generally what happens if you got convicted of 30 and let's say all 30 survived, they would all run at the same time. So even if you got convicted of 30, you would only basically serve time for one. That's if that happened, and that's way down the road. But I just kind of wanted to give you a brief kind of summary of where we are. We're at the very beginning, just an indictment, apparently. And then the real litigation will start after this. I expect it to be hot and heavy, and I will keep you updated as I learn things. Have a good day.